Greetings, class. Welcome to our first pre-recorded lecture. Before beginning the assigned reading materials that you were supposed to read on Monday, I wanted to first begin with a quick review. And so last week we began our chapter on debt. And so we started our discussion by first going over some of the characteristics of debt that are set forth in your casebook. And before getting into the characteristics, the book provided a very general definition of debt in that it's a form of financing arrangement characterized by the provision of credit. We already know this because we have reviewed debt in a number of other contexts through our chapter on valuation, for example. With respect to the characteristics of debt, we know that debt has a predetermined, agreed upon maturity date. That could be a short-term maturity date, which means that the principal is due within a year. It could be medium term, meaning that it's due between 5 to 10 years, as well as long-term. With respect to each of these debt instruments or contracts, the parties will have agreed upon either a floating interest rate or a fixed interest rate. They are also characterized by priority provisions. We've talked about priority in the context of debt having priority over equity in the event of a liquidation of a company or insolvency or bankruptcy. However, we have not talked as much about the extent to which certain creditors have debt in comparison to other creditors. And so we talked about these different levels of priority, such as senior, mezzanine, and junior. Other characteristics that we very briefly discussed, the extent to which each debt instrument carries a security interest. We discussed the extent to which each debt instrument is deemed creditworthy, and there are various mechanisms for rating the creditworthiness of a particular debt instrument. Certain debt instruments are convertible into common stock, and the extent to which debt is convertible into common stock would be embedded within the contract. Some debt is redeemable by the issuer before its maturity date, meaning that the issuer can simply pay the debt holders the principal amount before the principal is due at the end of the maturity date. And the extent to which debt instruments are regulated is also distinctly different than the ways in which common stock or preferred stock is regulated. And so for debt instruments, they are largely a product of contract. And so credit holders as well as bondholders, or creditors rather, and bondholders have to specifically negotiate for the particular protections that they would like to have under contract. They are not subject to the same protections that we see under corporate law. And we spent an extensive amount of time talking about some of the fiduciary duty protections that arise with respect to common stockholders and preferred stockholders. Some of these duties are baked into the corporate law statutes of each state. Some of these duties arise under common law standards, but creditors are not subject to the same level of fiduciary duties. Although we did discuss the extent to which certain fiduciary duties arise in the event of a default or a bankruptcy of a particular company. So we then reviewed a number of cases. This first particular case dealt with the extent to which debt instruments, in this case, the debt was classified as a Class B debenture, the extent to which debt should be treated as a security. And so this was an extremely fascinating discussion. In a federal Sec Reg course, we spent a great deal of time talking about how securities should be defined. We broadly discuss some of the characteristics of securities. One characteristic is that they have a residual claim in the assets of a company in the event of a repurchase or a distribution or reorganization of some sort. And so in this case, within the certificate or the contract that effectuated all of the terms of this arrangement, there was language that you see highlighted at the end of this provision, which definitely made it appear as if perhaps the debt holders did have a residual claim to the remaining assets of the company in the event that the company was completely sold off. And so instead of simply receiving the face value of the debt under this interpretation, they would be entitled to receive whatever is left over after the company has paid the face value of this debt. And so there was very interesting language in terms of how the issuer interpreted this language. The court ultimately agreed with the issuer in that this language did not create a residual claim in the same way that shareholders would be entitled to a residual claim on the remaining assets of the corporation. And then the court also talked about voting rights. And so these debt instruments did not carry any voting rights. And so that also affected the extent to which the court viewed these instruments as securities. And the court talked about how security holders could use their voting rights to take away some of the rights that our debt holders were arguing for. We then talked about some of the conflicts that could arise between shareholders and creditors. We know that the primary interest of creditors is to receive their interest in principal upon maturity, or a redemption, if in fact the issuer exercises a redemption right that would be embedded in the underlying contract. Whereas shareholders, their primary interest is related to wealth generation due to their status as residual claimants. So we saw in the previous case how, because the company had additional assets to distribute, it was actually great for the shareholders because they were able to have a claim in those remaining assets as residual claimants. And so you can see how these interests collide, particularly when a company is extremely close to insolvency. And we talked about the FedEx example where FedEx only had about $5,000 left in its assets, and the creditors presumably would have preferred that FedEx hold on to those assets, that the creditors could get whatever piece of that $5,000 pie that they are entitled to under their contracts, whereas the shareholders probably would have no claim to that remaining $5,000 once the company pays off all of its creditors. And so why not just go and gamble that $5,000 away at a casino, which in the FedEx example, it worked quite well for the company because they were able to increase the $5,000 to $27,000 in Las Vegas at a casino. But that bet could have gone horribly wrong. The FedEx employee could have lost all of the $5,000, leaving the creditors with nothing. And after discussing those conflicts and how those conflicts arise in certain examples, your book also utilized a different example that is referenced in the previous slide. We then talked about the unique regulatory framework that applies to bonds. And so this is where I really want to begin today's lecture. This is something we do not discuss at all in BA or securities regulations, simply because there is not enough time. There's barely enough time to cover the materials that are traditionally discussed in those classes. And so I think this is a really valuable opportunity to become familiar at least with the big picture components of how bonds are regulated particularly under the Trust Indenture Act of 1939. And so this is where the book talks about a bond indenture. And so this is effectively a contract. It is a contract between the issuing company, the company that is in fact issuing the bonds for sale to the general public. Okay, so it's a contract between the issuer, which the issuer is often referred to as the obliger. So it's a contract between our issuer and the trustee. And legally, the trustee is obligated to consider the interests of the bondholders as third-party beneficiaries. And so this contract, the terms of this contract, or at least the requirements of what this contract should include, are set forth under the Trust Indenture Act. It includes the obligations of the issuer. It includes the rights and remedies of the bondholders. It includes all of the various rights of the trustee. And we'll talk about some of these rights when we get to our cases. And I urge you to watch this lecture until the very end, because I also plan to go through in detail the Amazon example. And so at the end of our lecture on Tuesday of last week, I gave a list of questions, and this would have been an excellent exercise to do in class. You may have taken time to look at those questions, but at the end of this lecture, I will provide answers to those questions, and I think it's quite interesting to look at how Amazon structured its own indenture in light of some of the cases that we will review following this slide. So, why the need for this additional law? As you saw in your reading, there were various studies that were done that found that bondholders were not sufficiently protected. There were scenarios where the issuers were engaged in excessive borrowing. There were scenarios where the bondholders didn't receive enough information with respect to the rights and obligations attaching to the contract. There were scenarios where the issuing corporations were altering the priorities for certain creditors based on conflicts of interest. And we know now that some of these sorts of conflicts of interest are perhaps regulated under other areas of the law, but this was certainly a concern that arose in the passage of this law. And also, are issuing corporations failing to retain trustees at all, or even if they did retain a trustee, perhaps they didn't grant the trustee with the requisite powers that it needed to actually effectuate its duties. And so this is the backstory behind the passage of this law. Now keep in mind, if in fact a company sells bonds to the public for sale, the company still has to comply with all of the disclosure rules under the federal securities laws. For those of you who are taking SecReg, you know that a bond could most certainly fall within the definition of security. So they have to file their own disclosures under federal securities laws. But in addition to filing those disclosures, they also have to have this indenture agreement in place. So we then talked about this trustee role. This is a different sort of role, and I say different because in SecReg as well as BA, we spend a significant amount of time talking about the role of the board of directors of an issuing company, and how do the powers coincide with the powers of shareholders to vote, sue, and sell. And we know that the director shall manage the affairs of the corporation. But here we have a new party coming into play and somehow governing or overseeing the relationship between the issuing company and the bondholders. And so this trustee is subject to its own duties. And so there were a couple of cases and reading materials that gave us a broad description of what these duties entail, in that they administrate the bond terms, the covenants, including the payment of interest and principal, as well as to monitor and enforce covenants and other indenture provisions on behalf of bondholders. And so they really provide this administrative role in helping to facilitate the payments that actually go to bondholders. And so the coupon payments that they're entitled to receive periodically, the payment of their principal upon maturity. If in fact the issuer decides to redeem prior to maturity, they help the issuer to facilitate the transaction. And so their duties, and I think this is already mentioned in a previous slide, are set forth under the Trust Indenture Act, and the issuer and the trustee, they're provided with a certain amount of latitude to contract around the broad requirements that are set forth in this act. And so that brings us to one of our first cases, Elliott Associates versus J. Henry Schroeder Bank and Trust Company, which is on page 486. And so in this case, we had our three parties, and I thought it was helpful for these cases to actually go through who these various parties are. We have the issuer. The issuer is a company called Centronics. Our trustee is Schroeder. And as you saw in the cases, these trustees can be an investment bank. They could be companies such as Fidelity, and we'll talk about Fidelity and all of the various things and roles that a company such as Fidelity plays. And oftentimes these trustees are performing several different functions on behalf of a wide variety of clients. And then we had our bondholder, who is leading this case, Elliott, which was the holder of $525,000 worth of convertible debentures. And so Centronics, we could assume that Centronics had the right to redeem this debt within its indenture, and so they exercised their right. And attaching to this right to redeem was a notice period, which makes perfect sense. The company had to provide the bondholders with a certain threshold or required or minimum day notice that they were actually going to redeem these securities, and so, or bonds rather. So under sections 3.01 and 3.03 of the indenture, so 3.01 says that there's a 50-day prior notice requirement for the issuer to redeem these debentures, unless our trustee determines in its discretion that a shorter period is satisfactory. Under 3.03, that period that the trustee determines is more satisfactory has to at least be 15 days and no more than 60. And so in this case, the trustee shortens the notice period pursuant to these provisions to 15 days, right? And so our bondholders receive notice on May 1. They have 15 days to decide whether or not they want to convert their debt instruments, or will they go ahead and accept the redemption request from the issuer. And so we quickly learned that it was more profitable for our debt holders to simply convert their debt into common stock. And there's this really helpful diagram and description as to why it was more profitable that is provided on page 488 of your casebook. However, the shareholder realized something. The bondholder realized that, my goodness, the trustee effectively used its discretion to shorten the notice period. The effect of shortening that notice period is that now we were not able to receive this additional interest payment that we would have been entitled to. And that additional interest payment was in the amount of $1.2 million. Okay? So if in fact the trustee uses discretion to select this longer notice period of 50 days, the debt holders would have received an additional interest payment. And so our issue is whether or not the trustee was under a fiduciary obligation to consider the impact to these debenture holders in deciding to waive the 50-day notice period. Okay, so even though the trustee followed the provisions that were provided in the indenture, were they under a heightened fiduciary duty? And we know that fiduciary duties are effectively gap fillers in a contract. So even if the parties did not specifically agree to be bound by fiduciary duties within a particular contract, fiduciary duties arise under common law, they arise under statutes, that even by virtue of holding certain roles, such as being a director of a company or being the agent of a principal, you have a certain set of fiduciary duties that are owed to the principal. And here we are trying to determine the contours of the duties that apply to a trustee. So this next question, this May 16th redemption date probably was not arbitrary. Why do you think, this is a question taken from the casebook, why do you think the board of directors designated May 16th as the redemption date? They probably did want to avoid paying this additional interest payment. It was in their best interest to not have to pay this additional payment. So perhaps they did violate some sort of duty that was owed to our debenture holders. And so these next couple of questions help us to outline the contours of the fiduciary duties that apply to trustees under the Trust Indenture Act. So this question, how did the court describe the pre-default fiduciary duties of trustees? Well, under Section 315A of the Trust Indenture Act, no additional duties outside of the express terms of the indenture, except for conflicts of interest. Okay, so just to be clear, right, we have to draw a line in the sand here. So for when the trustee is exercising its duties, when the company is doing well, this is pre-default land, the company is not in default in terms of its ability to pay its obligations to creditors. Company is doing well. Trustee is not subject to heightened fiduciary duties, such as the duty of care, for example. However, the court did say that trustees could be liable for conflict of interest transactions, and we'll see an example of a conflict of interest transaction in the next slide. Okay. So how are these duties different than the duties of corporate boards? And I ask this question because I think it's helpful to connect this material to the duties that apply in VA, since this is an advanced topics in corporate law course. So why the lower threshold of duties? We know that directors are subject to a range of fiduciary duties, such as the duty of care, for example, which is a grossly negligent standard. They're also subject to the duty of loyalty, which includes conflict of interest transactions. It also includes transactions that could potentially breach the duty of good faith. It includes corporate opportunities. So this question as to why, I think we could very quickly think about some of the fundamental differences between the board of directors and a trustee. The board of directors shall manage the affairs of the corporation. In the context of a bond offering, the board went through a very detailed process in determining whether or not they should engage in a bond offering. The trustee performs a role that is very different than the board of directors. They are helping to administer the bond offering. So perhaps they shouldn't be subject to the same degree of fiduciary duties. And you may recall that I did a lecture weeks ago and I incorporated several additional slides that discussed the ways in which investment funds are regulated. And we know that registered investment funds include mutual funds, for example. And so you could go through a similar process in outlining the fiduciary duties that apply to the investment advisor of a fund. So a fund has a board of directors, which we talk about boards extensively in a BA course. The fund itself is a corporate entity. And then the fund may have a separate investment advisor that can be organized as a trust. It could be organized as its own separate publicly traded corporation or privately held corporation. And that investment advisor, similar to our trustee in this bond offering scenario, is subject to its own set of fiduciary duties. But perhaps, right, in looking at this second bullet, perhaps directors, in thinking about the effect of a 102(b)(7) provision, which exculpates duty of care violations for directors, not officers. Perhaps directors are also subject to a reduced level of fiduciary duties, and so that could lead to an extremely interesting and invigorating discussion in comparing the kinds of fiduciary duties that corporate boards are beholden to, that trustees are beholden to, that investment advisors are beholden to, broker-dealers are subject to their own unique sets of fiduciary duties as well. And there's a lot of research that dissects the contours of these duties and advocates either for heightened duties on one end of the spectrum or lower duties on the other end. So if there was actually a duty of care that applied to bondholders, the issuer probably would have been obligated to comply with the 50-day notice period, and the trustee, okay? The management of Centronics could have avoided this by perhaps providing a notice at least 50 days prior to the May 15th date that, or May 16th date that was used. So the court ultimately held, as we know, that the trustee had no express duty to consider the interest of the debenture holders in deciding to waive the 50-day notice period. And so there was also an interesting discussion in this case where Congress debated the issue of whether or not to impose heightened duties on trustees. I already highlighted some of these discussion points in comparing the duties that apply to corporate boards and trustees and thinking about the different functions of a trustee versus boards of directors. And you could compare or kind of integrate other components to this discussion, such as, well, perhaps bondholders should enjoy greater protections. However, to the extent that trustees are subject to heightened fiduciary duties, that would increase their litigation risk, right? So you can see how complaining bondholders could cast a wider net or include a greater number of potential litigants. And so in addition to kind of throwing the boards of directors into the mix as potential defendants, then you would have trustees, right? And so perhaps, and we know that those litigation expenses ultimately get passed down to underlying shareholders and perhaps bondholders, and thinking about the prices of their offerings and how those prices fluctuate within the marketplace. Okay, so that brings us to our next case, Rubart versus North Jersey District Water Supply Commission. This is on page 491. And so here in this case, we actually have a conflict of interest, right? Remember, In our last case, there was a carve out for conflicts of interest that may occur when a company is in pre-default land, right? The company is doing well. And we know if the company is doing well, the trustee is not subject to heightened fiduciary obligations, except for potential conflicts of interest. So that brings us to this case. Here are the parties. We have North District Water Supply Commission as the issuer / obliger. Our trustee is Fidelity. And I included a link to Fidelity. I can't really click on this link in this format of recording, which I actually really like this format. I'm excited about it. But if you were to click this link, and I believe we've talked about Fidelity in other context, you'll see all of the various roles that Fidelity performs. Fidelity serves as an investment advisor to a range of investment fund, mutual fund, ETF products. They also serve as broker-dealers, where they are earning a commission for selling securities, bonds, and other kinds of financial instruments to investors. They can also serve an underwriting role, which we saw in this case. And in this case, we saw that they also can serve as trustees. They can also serve as trustees in helping issuers to administer all of the various contractual obligations of a debt offering. And so Fidelity performs many roles. And so you can see how conflicts would naturally arise when Fidelity is attempting to fulfill all of the various fiduciary duties that it owes to different clients in different contexts. So in this case, the issuer decided to redeem bonds prior to the maturity date of June 23rd, 1986. Okay, kind of a similar fact pattern in that the issuer was seeking to exercise its redemption right. As a result, there are these notice requirements that are embedded in the indenture. Fidelity, in its capacity as trustee under this arrangement, did comply with its notice requirements under the indenture by publishing announcements in newspapers. Okay, that was the essence of the notice requirement. So you can envision a scenario where some bondholders will see these announcements that are published in the newspaper, whereas others may not. But Fidelity, for the bondholders that were also its clients, in performing its broker-dealer role, Fidelity contacts those clients and provides them with direct notice. And so those clients very quickly take advantage of this redemption right. And as a result, they were able to earn a higher return as a result of redeeming at this earlier date. And the court here was determining whether or not Fidelity was under a fiduciary obligation as trustee to notify all of its bondholders in the same exact way. Okay, so because they took this additional step that was not required under the indenture to notify the bondholders that were also their own personal clients, that is what created an issue here. And so the court ultimately held that Fidelity acted unfairly when it selectively notified certain bondholders but not others. This demonstrated a clear lack of fair dealing, good faith, and a potential conflict of interest. Now, just to be painfully clear, if Fidelity did not specifically notify any of the individual bondholders and they simply complied with the indenture and published the notification in the newspaper, no liability. Now, this argument I thought was interesting where Fidelity tried to argue, look, there is this impenetrable Chinese wall between the functions that we perform via our brokerage arm versus our trustee arm. And the court kind of really, I thought, did a pretty decent job outlining how these roles conflicted, and that Fidelity in its role as broker actually, it actually underwrote a percentage of the bond offering. And so they actually purchased a chunk of this bond offering and sold those bonds to its customers through its brokerage arm, while also serving as trustee. And so the court didn't really buy this Chinese wall argument. And the court said, gosh, these two activities were not sufficiently separate. This is a holistic corporation. These fiduciary duties apply to the corporation. And the essence of the conflict is that there was a benefit that accrued potentially to Fidelity in giving their clients advance notice, because by doing that quote unquote favor to their clients, they could have perhaps received additional revenue in future business, right? Maybe that could have been a way of retaining those clients that would have otherwise left to go to a different broker. And so the essence of the damages, this brings us to the last question, would entail the lost benefit to the bondholders, of course, but also a disgorgement of any benefit received by Fidelity due to the conflict of interest. Okay, and at this point I would ask if you all had any questions, but unfortunately I cannot do that today. So that brings us to our third case, LNC Investment Incorporated versus First Fidelity Bank, which is on page 493. And so this case actually deals with a scenario where the issuer is in default, where the issuer is not able to pay its debts and obligations. And as a result, this issuer files for bankruptcy. And so how does this change the fiduciary duties that apply to the issuer and the trustee in the context of a bond offering? And so what was the nature of the fiduciary breach? So the parties here, the issuer is Eastern Airlines Incorporated. The trustee is First Fidelity Bank and National Westminster Bank. The bonds in this case, okay, in this case, were actually secured by a number of aircraft. March '89, Eastern files for bankruptcy. Interestingly enough, the bondholders purchased the bonds between September '89 and March 1994, after the company files for bankruptcy. And so I want to talk about why bondholders would do this in the next slide. And so here the issuer is whether or not the trustee breached its fiduciary duties by failing to take proper steps to lift the automatic stay for these aircraft and take additional measures to ensure that these bondholders could effectively receive the security interest of this collateral, these aircraft. And then an additional issue here, which is really the heart of this case, is determining whether or not the bondholders are required to prove reliance as a component of causation. So why would bondholders purchase bonds after Eastern filed for a voluntary bankruptcy petition? What is going on here? Why would they do such a thing? And so this sort of scenario where a company is in bankruptcy can present an extremely profitable opportunity for certain kinds of investors. And oftentimes you see hedge funds who attempt to take advantage, and I'll talk about why that is in a second. Oftentimes it's hedge funds that are able to take advantage of these kinds of opportunities, where they can purchase the bonds at an extremely steep discount, and whatever they are able to recover via the bankruptcy proceedings could exceed the purchase price. And so these hedge fund investors have certainly done their due diligence. They They saw that these bonds were secured by these aircraft. They probably underwent some sort of their own internal valuation process in determining how much it would be worth. And we saw in the case that if in fact were able to secure that collateral at an earlier date, they would have received an amount that was in excess of the face value of these bonds. Another context in which you see this sort of strategy occur would be in the context of vulture funds. For those of you who watch Billionaire, there were a few episodes, and I can't remember which season, where the hedge fund was engaged in a strategy of this magnitude. And full disclosure, I didn't watch all of the episodes, but I thought it was fascinating that it highlighted this sort of scenario where hedge funds will buy the debt of a distressed economy, such as a municipality, for example, or a city or a country, and they'll buy the debt at an extremely discounted rate. And because hedge funds oftentimes have a significant amount of capital at their disposal, they can then litigate, right? They have the resources to litigate via bankruptcy through this sort of litigation. In the context of vulture funds, they have the resources to litigate with respect to the municipalities and say, look, if you don't pay me this debt, we will force you to implement all of these austerity measures where you have to cut back on education and you have to cut back on your retirement accounts for government employees, and you have to make all of these various cutbacks in order to pay the debt. Okay, and so they actually have a lot of capital at their disposal to engage in these sorts of battles with municipalities, cities, and countries to enforce these sorts of austerity measures where they would be able to actually receive the face value of the debt, which is higher than the steep discount in which they were able to purchase the debt at. Okay, so I thought this was a very interesting sort of backstory in understanding why companies would purchase debt even if the company is in bankruptcy. Now, the trial court instructed the jury on the prudent man standard. In Elliott, one of our previous cases, the trustee's duties were defined by contract. No additional duties beyond the avoidance of conflict of interest attached. What accounts for the different legal standard? We already know the answer to this. Section 315C of the Trust Indenture Act provides heightened fiduciary duties for the trustee if in fact our company is in default. Okay? If it's in default, the trustee, pursuant to this provision of the Act, must exercise its powers with the same degree of care that a prudent man or woman, I probably will start to add woman going forward, at this juncture of my academic career, would exercise under the circumstances in managing its own conduct, his or her own conduct and affairs. Okay, so we've seen this prudent man standard several times before. And so how does this all relate to this reliance requirement? So if our defendant was correct on the issue of reliance, why would the bondholders have lost the case? Well, the defendants are arguing that the plaintiff bondholders actually had the duty to prove reliance as an element of causation. Since the bondholders purchased the bonds after the issuer filed for bankruptcy, then it would be harder for bondholders to prove that they had no knowledge that the trustee did not fulfill its obligations by acting imprudently, right? If our bondholders are purchasing after bankruptcy, then perhaps they knew that the trustee was not acting in a way that was prudent, okay? However, the court ultimately held that plaintiff bondholders do not have the burden of proving reliance as an element of causation. Even still, the plaintiff's knowledge of the trustee's imprudence could be a factor in the defendant making the affirmative defense of waiver, estoppel, or ratification. The defendant has the burden of proving the various elements of these affirmative defenses. As the case highlights, this is a higher burden to overcome. Okay, this is a higher burden to overcome because our plaintiff bondholders have to prove that, or the defendant actually has to prove that the plaintiff bondholders completely had knowledge that they abandoned known rights. Okay, and so that brings us to our last case, United Health Group Incorporated versus Wilmington Trust, which is on page 500. So what was the nature of the alleged breach in this case? Before getting to this, we have our parties, United Health Group, UHG. The trustee was Wilmington Trust Company. The plaintiff bondholders, once again, are hedge funds. They tend to have the resources to bring this sort of litigation, and sometimes they have strategies that are rooted in bringing these suits against issuers. The hedge funds own 25% of the bond issue. And so this case is fascinating in that it deals with the ways in which the Trust Indenture Act intersects with the disclosure obligations under the federal securities laws. And so in this case, UHG, our issuer, failed to file its required 10Q report in a timely manner due to internal investigations related to option backdating. You may have discussed this phenomenon in SecReg or BA. Several companies were engaged in this practice. It garnered them lots of negative publicity, exposed these companies to fiduciary duty, to litigation related to fiduciary duty breaches. So as a result of having to deal with these investigations, UHG was late in filing its required quarterly 10Q report. And so in a SecReg course, we spend a lot of time talking about the various requirements of the registration statement, which must be filed as if a company decides to do an IPO. These periodic reports, such as the 10Q, which is the quarterly report, the 10K, which is the annual report, there's the 8K, which is a report that is required to be filed when certain material events happen with respect to the company. All of these additional reporting obligations arise under the Exchange Act of 1934. And so you could take a quick look at some of these reports. Amazon is the example that we are going to review when we look at the indenture example following this case. If you look at the Investor Relations tab for Amazon, so if you just go to their homepage and scroll to the bottom and click on the Investor Relations tab, you could actually take a look at some of these reports. And the effectuating regulations under the Exchange Act are very detailed about what precisely is required to be disclosed within each of these reports, the extent to which they require audited versus unaudited financial statements, as well as the time in which these reports must be filed with the SEC. And so under these Exchange Act rules, UHG was late in filing its 10K report. However, there was also a section under the company's indenture, right? This agreement between the company and the trustee that sets forth all of the rights and duties of the trustee as well as the holders of various debt instruments. There is a provision, right, under this indenture, it's 504I, that talks about the extent to which the company is obligated to deliver these reports that are filed with the SEC to the trustee, right? So it makes sense that the trustee would also want to have copies of these reports. If in fact the trustee, if in fact the issuer failed to comply with 504I of the indenture, it would force UHG to accelerate its payments of the principal amount of the notes in this particular case. So this is a big deal. And so the court first went through the process of interpreting the plain meaning of 504I. So they looked at the plain meaning of this provision within the indenture. It provides that the SEC reports must be forwarded to the trustee within 15 days of actually filing it with the SEC, irrespective of whether or not the filing is late, okay? So here, I believe the company filed it 7 months late. As long as the company gave the trustee the 10Q within 15 days of that late filing date, totally fine under the court's interpretation. Okay, not within the 15 days of the required filing date of such reports. And so the court had a different assessment in terms of how to interpret this provision. Okay, within 15 days of actually filing it with the SEC, irrespective of whether or not such filing is late. The court also talked about how this provision was affected by or interacted with Section 314A of the Trust Indenture Act, which this particular provision provides a really broad statutory obligation to provide SEC filings to the trustee. But the court is saying, gosh, this is a very broad provision under the Trust Indenture Act, and it's actually less restrictive than the provision agreed upon under this particular indenture, in that it doesn't even include any time constraints. It really just sets forth this general obligation. And so the policy rationale for interpreting this provision as a ministerial function, well, gosh, perhaps we don't want to give too much teeth to this obligation to deliver required SEC filings to the trustee because the issuer is already subject to stringent disclosure obligations under federal securities laws. And so to create concurrent obligations that carry a lot of teeth and weight perhaps would be excessive, which is very much related to this next question. The issuer and bondholders can negotiate, right? They get to negotiate a term in which the indenture requires an independent obligation to provide information. However, from the issuer's perspective, what might an objection be to such a duty? Okay, so you can see how this could be problematic, right? Like if UHG revised its language to clearly set forth an independent obligation to provide the trustee copies of these reports in the same time frame in which they are to be provided to the SEC, that could be excessive, right? Because once they file it late with the SEC, then it's late to the trustee, then they have additional liability to the trustee. So you could see how having that sort of dual requirement or that independent contractual obligation could be deemed excessive by issuers. Okay? And so that brings us to our exercise. And so at the end of our last class, I instructed students to take a look, right? To take a look at an actual example of an indenture, right? Because this is something we have not reviewed probably in any of our business law courses that are traditionally offered. We have looked at registration statements. Perhaps you've looked at a 10K or a 10Q or an 8K. I know in my BA course, we've looked at the bylaws for a particular corporation. We looked at the certificate of incorporation. We looked at the corporate charter, but we have never actually looked at an indenture. And so I have a range of questions here, and I have a number of slides that are dedicated to directly answering these questions. And so this first question, how are securities defined under this indenture agreement? And so under section 1.1, this definition of securities seems to encompass a wide range of debt instruments, right? The debentures, notes, or other debt instruments of the company of any series authenticated and delivered under this indenture. So it seems to be a broad definition. Is there an authorized amount of such securities embedded with the document? So I asked this question in an effort to get students to think about how this would relate to a corporate charter, where we would see a provision that authorizes a certain number of shares, and usually that amount is really, really high, so that the company is not forced to amend and restate its corporate charter in the event that they want to offer more securities. But here, there is no such requirement to have an authorized amount of shares. In section 2.1, the aggregate principal amount of the securities that may be authenticated and delivered under this indenture is unlimited. Okay, so they don't have to deal with this whole notion of creating a ceiling of authorized shares. So the next question, does the company retain the right to redeem securities? And so we see under section 3.1 that the quick answer to this question is yes, very much consistent with the powers or the power to redeem by issuers that were provided in our previous cases. And so 3.1 provides that the company may, with respect to any series of securities, reserve the right to redeem and pay such series of securities, or may covenant to redeem and pay such series of securities or any part thereof prior to the stated maturity thereof. And then there's some additional language, right? And in practice, you would have to be very, 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 very careful to read everything. Read the definitions. So there's a long list of definitions provided at the beginning of this document to see how those definitions may affect the interpretation of an applicable provision. And you have to look at how these provisions interact with one another. And oftentimes there's a reference to a different provision. So that's my disclaimer. I'm kind of looking at very brief answers to my questions, but the answers can actually be more nuanced. And so in thinking about this right to redeem, there's also, you can see an example of a notification requirement. So unless otherwise indicated for a particular series by board resolution, officer, certificate, or supplemental indenture, at least 30 days, but not more than 60 days before redemption date. So here our trustee does have some discretion here. Okay. The company will deliver a notice of redemption to each holder whose securities are to be redeemed in accordance with 10.1. Okay, so there's some wiggle room in determining what exactly this notification period should be. At least 30 days, but not more than 60 days. And then there's a lot of other language within this provision that you would have to read. Okay, so next question. Describe some of these covenants. Describe some of the covenants made by the company to the holders of the securities. And so I asked this question because here is where you see a description of the contours of the fiduciary duties that, no. That is the next question. So here on this particular slide, this is where we see a description of the reports that the issuer is required to give the trustee. And so this first provision is pretty basic. We know that the issuer covenants and agrees for the benefits of our securities holders, which in this case our securities holders are holders of this range of debt instruments, that it will duly and punctually pay the principal. That's good. We want them to pay the principal. And premium, if any, and interest on, yes, We know that we would want that, on the securities of that series in accordance with the terms of such securities in this indenture. There's a lot of language following this provision. Now, a question that I did not include here would be the default events. And so you could look at, for those of you who are interested, you could look at this indenture to look at the default events, right? And so I'm guessing that failure to be punctual, the failure of the company to be punctual in paying the principal and the premium and the interest probably constitutes a default event. And the implications of these default events are provided in this indenture. And so reports, okay, whether or not required by the rules and regulations of the SEC, very similar to the case we just looked at, so long as any securities are outstanding, the company shall file with the trustee within the time period specified by the SEC's rules and regulations, copies of, okay, so this seems to be a more stringent provision than our last case. Shall, that's a requirement, file with the trustee within the time period specified by the SEC's rules and regulations. This is different than our last provision. Our last provision said, gosh, after, something to the like of after it's actually filed, or within the period, or after it's actually filed with the SEC, irrespective of whether or not the filing is late. Here, different. Okay, within the time period specified by the SEC's rules and regulations, copies of the annual reports and of the information, documents, and other reports that the company would be required to file with the SEC under these provisions of the Exchange Act, okay? So here, it appears that the company is under a heightened obligation to file or provide copies of these reports to the trustee within 15 days in which they are required to be filed with the SEC. Very interesting. Next question, who is the trustee? Right, I think it's, we kind of talked about who these trustees are, what kinds of institutions these trustees are. Here, the trustee is Wells Fargo's bank, okay? Fidelity was a trustee in one of our previous cases. And so what are these duties? What are the duties of the trustee? And so here, this is what I started to talk about in the last slide. Here's where you see the fiduciary duties of the trustee outlined, okay? So B, A, if an event of default has occurred and is continuing, okay, remember this is a line that we draw in the sand in examining the contours of the fiduciary duties that trustees owe to its bondholders. If an event of default has occurred and is continuing, the trustee shall exercise such of the rights and powers vested in it by this indenture and use, here's our prudent man and woman standard, and use the same degree of care and skill in such exercise as a prudent person would exercise, or use under the circumstances in the conduct of his or her own affairs. And so we see a reference to this prudent person standard embedded into this indenture. B, except during the continuance of an event of default with respect to the securities of any series, the trustee need perform only those duties, right? This is non-default land that are specifically set forth in this indenture and no others. And no implied covenants or obligations shall be read into this indenture against the trustee other than is required under the TIA, okay? This next provision deals with what occurs when bad faith, right? In the absence of bad faith on its part, the trustee may conclusively rely as to the truth of the statements and correctness of the opinions expressed therein. C is interesting, okay? There's more language that I did not include in this provision. The trustee may not be relieved from liabilities for its own gross negligence. That looks like a duty of care violation, or its own grossly negligent failure to act, or its own willful misconduct. That looks like duty of good faith. And so there seems to be a possibility under C for trustees to be liable for grossly negligent conduct or willful misconduct. Okay, so in evaluating the extent to trustees would be liable for fiduciary duty breaches, it would be essential to comb through these provisions with a fine-tooth comb, because you see in these kinds of litigations, the court starts with the indenture agreement to see specifically what the parties have agreed to, and then they also look at the extent to which the TIA interacts with these contractual provisions. Many aspects of the TIA are default provisions. However, there are certain core aspects that cannot be contracted around. Okay. Can the trustee, right, can Wells Fargo actually hold securities? Section 7.3. The trustee in its individual or any other capacity may become the owner or pledgee of the securities and may otherwise deal with the company or any of its affiliates with the same rights it would have if it were not a trustee. Okay, so the answer to this question is yes. Next question, can the holders of the securities remove the trustee? The holders of a majority and principal amount of then outstanding securities of any series may remove the trustee. So the answer to this question is yes. The holders have the power to remove the trustee. If you look at this subsequent language that I did not highlight, the company may also remove the trustee for any or all series of the securities if the trustee fails to comply with 7.9, if the trustee is adjudged bankrupt or insolvent, if the trustee is incapable of acting. So you can look at all of the various scenarios in which both the holders of the securities as well as the issuing company is obligated, or not obligated, is empowered to actually remove the trustee. So that